even if we were just to isolate the couple of charges that TSu Surf has been charged with, those are very serious charges in and of themselves, whether it was at the federal level or the state level. He's alleged to have shot a rival gang member. He's alleged to have coordinated a drug deal via actually Instagram of all places. And moreover, he has a prior felony conviction. He's charged with having possessed a firearm, which becomes a federal offense when you have a prior felony conviction and you possess a firearm that was manufactured across state lines. And in New York and New Jersey, the guns typically that are found here were not manufactured here. So they fall under federal jurisdiction. So those charges just separately and apart would be serious enough. But when you then combine them with those acts being alleged to have been a part of a grander overall criminal enterprise, what it really does is it ups the sentencing exposure. I mean, we're talking about an individual right now who's facing, at least 20 years. That's just talking about on the racketeering counts. And then if we start to talk about consecutive time with respect to the drug deal, with respect to the shooting, with respect to being a felon in possession, this is a lot of time, Lisa.
So he's conceivably looking at the minimum, if found guilty, 20 years, and then he could conceivably end up spending the rest of his life behind bars.
20 years, I can tell you, is certainly a number that's resounding in his head right now. Depending on how you go in, if you decide to plea bargain, if certain counts are dismissed at a certain time, you can never at the inception have a full understanding of what the sentencing exposure may be. You just look at what the charges and sentencing exposure are in terms of the indictment that you're dealing with. And with respect to the indictment that TSu Surf is dealing with, 20 years is certainly a number that is probably in his head and one that's causing him most likely a lot of anxiety.
Now, in terms of the other defendants, there's 10 defendants on that particular indictment. Does he, what typically happens when you have a multi-defendant indictment like that or case like that, where there's so many people being charged with a variety of different things in these alleged conspiracies?
I mean, you have a lot going on. Let's just start with the fact that there's going to be a lot of discovery being just a lot of evidence that the government is going to have to turn over to the respective defendants so that they can assess what the strengths and weaknesses of their cases are. A lot of times when you're dealing with a multi-defendant indictment, the government will issue protective orders in regards to the discovery, such that if I am representing one client, I may not be in a position where I can share certain information with the attorney for another client, right? Because the government doesn't want, in many respects, a lot of information to get out. And then you start dealing with issues such as witness retaliation or, people learning more information that can help them get an edge on the case that doesn't necessarily involve evidence from their case. So you deal with a lot of the protective orders. And also a lot of times, Lisa, you deal with out of those 10, 15, 17 defendants that may be listed on an indictment, somebody oftentimes is cooperating with the government. And
I was going to ask you about that. They're called cooperators on the streets. They're called snitches. How common is that in these big federal cases?
It's extremely common, if not always just a happenstance, right? Like this is what happens in federal prosecutions. Out of 15, 17 people, you can't say that 100% of them are comfortable with the exposure that comes with federal sentencing. Some of them may be, and they may decide, hey, I'm not going to snitch. I'm going to live by the codes of the street. But very much so often you have people who have families, who have other collateral considerations that they say, hey, I can't sit on 20 years. I can't sit on 25 years. And if the government is offering me an opportunity to give up information on all of my cohorts from the street, even though it goes against street code, I'm going to do it, and I'm going to give up that information so that I can be in a position where I can undercut the mandatory minimum and maybe try to get myself a sentence of 2-3 years. Tekashi 6ix9ine comes to mind.
And then when you look at the Tekashi 6ix9ine and the 9 Trey Bloods case that was in Manhattan, the U.S. attorney in the Southern District there, he was actually in contact with the feds before the whole indictment thing came down. And then he was facing over 40 years, and then it was reduced down to a couple of months and time served, which was basically a couple of years that he'd already been locked down. How typical is that?
It's typical. I mean, to the extent that you provide substantial assistance to the federal government, they want to incentivize future cooperators having an understanding of, hey, if I work with the government, I could end up in a good situation where I'm getting a 2 or a 3 month sentence or a 2 or a 3 year sentence where otherwise I was facing upward of 40 years to life. And so the government wants that to be known. And in order to do so, they have to, do well on their promises. And so what you do often very much so have are these cooperators that come in, and there's a race to be able to be the best snitch, to give the most information more than anyone else can, so that you can guarantee yourself the best deal. And when we talk about how common is it, it's pretty much regular practice.
And why are these cases so difficult to beat?
Because they have been investigated for years on end. And so often we're talking these days, social media, we're talking, with respect to a lot of rappers, lyrics that are coming out of their mouths that look, there's an old saying, Lisa, that you can make a federal case out of anything. But when you're actually in federal court watching that case play itself out, what you really come to find is that those years of evidence, those statements, those pictures of maybe you holding a gun or you holding the drugs that's ultimately alleged to be the core of the case and the charge with which you are charged with, it becomes difficult at a certain point to say, well, that's not me. Well, clearly it is you. That's your Instagram handle, and that's a picture of you that is within the account holding the contraband that we're currently charging you with. And so at that point, what it breaks down to is, if we can't beat the charge, can we at least mitigate the sentence, right? And when we start talking about mitigating the sentence, that's when the S word starts to come in regards to snitching. That's when, some of these other, plea bargains start to come in, where people decide, hey, I don't even want to fight this. If I save the government the time of going to trial, maybe they'll look out for me and give me a reduced sentence. And that's how a lot of those conversations start to come into play, because it is very difficult to beat these cases. Not impossible, but very difficult.
Because you have beaten them, but you've told us on Street Soldiers, Phil, you call it self-snitching in a sense with the social media, and that's named in they name Instagram and Facebook postings in these indictments. Explain that to us, because some people think, okay, the feds are looking at social media, they're looking at music videos, and then they're making indictments off the music videos, or does the crime have to come first? How does that work?
You don't necessarily have to put the cart before the horse, or vice versa in these situations. There are times where they will simply have hip hop police, right? We are familiar with that colloquial term. And they will just be scrolling these days on social media, looking for instances of people who are coming into a lot of money, potentially tying that with lyrics from songs that deal with drugs or violence, and starting to figure out from maybe contacts that they have on the street, well, who's who? How is this person getting this money? What are they involved in, right? So sometimes there are investigations that just start from there and go to the top. Other times there are arenas where they actually do have evidence of a crime having been committed through information that they may have from confidential sources, from snitches. They start to zero in or target someone. And once they do that, they start going through that person's social media ad nauseum, their IG, their TikTok, their Facebook, you name it. And to the extent that they're able to start putting puzzle pieces together from that social media that connects with the theory of the case that they plan to put before the jury as to why this defendant is guilty, they'll do it. And that's where so often you have a lot of people who, maybe even unbeknownst to themselves, are self-snitching because they never necessarily thought that they would be the target of an investigation.
Right.
But once you become one, now there's all this evidence that you've put out against yourself, that how are you going to fight that? That's where it becomes really difficult in federal court at times. I can cross-examine a cop. I can cross-examine an FBI agent. But when my own client has essentially provided the bulk of the evidence against themselves, it gets a bit difficult.
And then what advice do you have for people? Because there's a certain number of, the gang affiliation, people are very flagrant about that on social media with hashtags, with different emojis that represent certain sets, all of that type of thing, who they're posing with, different, hand signs for the sets or whatever. What do you think about posting all of that? How risky is that? Are they really watching all the time?
It's super risky, and you should presume that they're watching all the time, even if they're not, because they can retroactively go back. They can, file subpoenas with Facebook, with Meta, with whomever they need to go back and maybe even get posts that have since been deleted. You should always presume that you're being watched and act accordingly. And when you start being in a position where you are hashtagging affiliations, even if it's not a real affiliation, even if it's a situation where you're just trying to get validity for your own music career or
Right.
authenticity in some way to be more reputable within hip hop, what then starts to happen is now you can get yourself tied up into a grander RICO case, because where you may be saying like, hey, even to the extent that I sold drugs, I was just doing that personally to finance my music career. But then when the government says, but hey, every hashtag you put said the Bloods, or it
Right.
said the rolling, 60s, or it said X, Y, and Z. Now you are a part of X, Y, and Z. even if really you were just doing it for the street cred on social media, right? But it doesn't matter, because when you're sitting before that jury and hoping that this jury, that most often are not the biggest hip hop fans, particularly in federal court jurisdictions, and hoping that they can put the pieces together that you're not actually a gang member, you just don't want to be in that situation.
And then Phil, how far back can they go? Because we saw in this superseding indictment with that TSu Surf was named in, that the allegations against him went back to, I think, 2019, and then the whole case, the earliest one I think was started in 2015. How far back can they reach in these RICO cases? Is there a statute of limitations?
Well, within RICO cases, just as a predicate, a place to start, they're always looking for, has there been at least 2 acts of racketeering, say, within the last 10 years, right? Like, you can just start there. There are other arenas, however, particularly when you're talking about conspiracy law, that if you have an ongoing conspiracy, right? Let's say we started something, you and I, Lisa, we made an agreement to, carry on some illicit activity and like build an organization around that, starting back in 2010. And every day of every year since then, we have committed acts that go toward the completion of that conspiracy, towards the profits that we were looking for that conspiracy. Even though at this point that was 12 years ago, it's been an ongoing conspiracy. We haven't gotten out of it. We haven't revoked our participation within the conspiracy. And so to that end, even though it's been that long, when did our criminal acts toward the conspiracy ever actually stop? So that wouldn't stop the statute of limitations, and it would totally make anything that we did back in 2010, 2011 actionable in terms of the US government coming against us for criminal culpability.
Why do you feel that we're seeing so many more of these RICO cases? Is it because they've been watching? Is it because there's been an increase in alleged gang activity and criminality? We are in a big crime wave in the United States right now, everywhere. What do you think is happening, or what do you see happening?
I think it's that. I think it's a lot of the media attention that, is right now being focused on, a lot of the crime that we have at least being reported. I think also it's just the nature of the music and like what's being inundated upon YouTube and these other outlets when we talk about the gun violence, when we talk about the drug dealing, when we talk about just the large sums of illicit money, the trafficking, all of these types of things that make up a lot of the crimes, let's just say like in the digital internet era. It also makes it a lot easier for federal authorities and for law enforcement to investigate these crimes, right? So it's actually much easier to bring a RICO, I would say, for the feds now than it was in 1991, when you had a lot of activities that literally were in the underworld. But the underworld now is displayed as much on social media as any legitimate corporate entity is advertising for you to buy their product on the internet, right? Like, it's just so much easier now to see acts of criminal activity that can, serve as a foundation for a RICO case than it was 30 years ago. And I think that's a large part of why we're seeing a lot more RICO cases now.
Okay, and then in terms of TSu Surf, I was told by his manager earlier before he was picked up that he had an attorney. I tried to find out the name, and then I was never able to get the name of the attorney. When he was presented in federal before the judge last Friday, that was October 14th, 2022, he was there was an attorney, a court-appointed attorney, who I guess handles, appearances when people don't have lawyers in place, which is not that uncommon, I don't think, in the beginning of some of these cases. But the judge said to him he could not keep a court-appointed attorney or be assigned one for his case because he made too much money. So what does that tell you? Does that mean they were already looking at his finances, or does it just mean how do you interpret that?
Well, I mean, listen, when you are initially presented in federal court, otherwise known in state court as an arraignment, right? Like, when you're initially presented before a magistrate judge, there's typically a financial form that has to be filled out to determine whether or not you do actually qualify for court-appointed counsel via the Criminal Justice Act, right? And if you are reporting either income or assets that clearly are above a level wherein you would qualify as, say, an indigent defendant for, free legal assistance and free legal counsel, then of course, like, the government is not then going to expend that money representing you when you have the money to represent yourself. And so most likely, either A, the government does have information that there are a number of either properties or assets or just a financial amount that ultimately TSu Surf should be retaining his own counsel, or he self-reported that. Either which way, at this juncture, what he's going to have to do is retain counsel. The court's going to give him the time to do so. And then once that counsel is retained, then he can ultimately move forward with starting the process officially of defending the charges.
So let me ask you this, how long can he go on being detained at Essex County Jail in the federal lockup there, still searching for a lawyer? Is there a time limit? Do they say like you have to have somebody in 30 days, or do you have, how does that work?
I mean, eventually the court is going to force the issue. Right now, most likely what's happening is either TSu Surf consented to a waiver of time following the initial presentment so that he ultimately can go out and retain counsel, or even if he wouldn't have consented, on a good cause application from the government or just on behalf of the magistrate themselves, they may have just excluded time that otherwise would have put the government on the hook for moving forward with prosecuting the case so that he can exercise his Sixth Amendment right to go find effective assistance of counsel to defend him on, as we've noted, what are very serious charges.
Because so there it sounds like you're saying there is a clock, that there is a clock that starts at a certain point with the case, like when as it has to move forward. Is that right? Like once he has a
Absolutely. Like once you are presented in federal court, the clock begins ticking on behalf of the federal government to move forward with either an indictment or trial. What is very customary in federal practice is that at the inception, most defendants, via advice of their attorneys, will essentially ask for the clock to be stopped, and the judge will grant that request because you need time. You need time to go through the discovery. You need time to figure out what's going on. A lot of people are trying to figure out, how am I even here? Why did the feds just arrest me last night? It's going to typically take more than 30 or 60 days, which at times is the clock that the government is held to with respect to various things that they have to do after an initial presentment. You don't want the government moving light speed ahead when you have no idea what's going on. You want to be able to kind of catch your breath, get a grasp of what you're dealing with, and then at that point, start the process of fighting back against the government. Remember, they, typically being the government, have had a 2, 3, 4-year head start in knowing everything about this investigation, everything about your life. You don't know a thing. You don't know who's been cooperating. You don't know how you're here. So the courts are always going to give defendants the time to catch themselves up to a 4-year, 5-year head start that the government has had since the inception of the investigation.
So the next point for him, that the spokesperson for the U.S. attorney said, for the prosecutors, said he chose to be detained, like he had a choice while he got an attorney. So the next step would be, and that he has not entered a plea yet. So let's assume once he does get an attorney, what would be the next step for him? What's the next step in this process?
Well, the next logical step would be to, of course, retain the attorney and then start the process of seeing whether or not you can put together a bail package. So most likely the reason why he just consented to the detention was, what's the point of making an argument to get out when you don't really have enough to show both the government and or the court that you will be able to be reasonably assured to come back to court. Of course, in this case, there is a presumption of detention because of the nature of the charges. That's just typically what comes when you're dealing with these violent offenses that are couched within a RICO conspiracy, right? There's a presumption that the person that is charged with that should be detained. So he's going to have to fight back against that presumption. It's totally rebuttable, and it can be rebutted, but you're going to need information. You're going to need assets to show. You're going to need family members to vouch for you, that they will ultimately be on the hook for a certain amount of money in the event that you flee or you go away. And you're going to have to convince the court that you're not going to be a flight risk and that you're not going to be a danger to the community. You can't just do that day one. Oftentimes in these kinds of investigations, you typically need a week or more to kind of put that information together such that when you do go to make that argument in front of the court, you're coming with something compelling as opposed to just something kind of ad hoc and just at whim on that particular day. So he's going to take his time. He's going to put his case together and then probably make his case for some sort of bond so that he can get out. But it's going to be an uphill battle for him, I'll tell you that.
And then is there actually in federal court in a case like this, is there an actual arraignment? Like at a certain point, does he enter a plea of not guilty?
Yes, there will come a point where he will enter a plea of not guilty. That will most likely be once he does retain counsel, because of the fact that we're already dealing with an indictment. It's not like he was arrested via a complaint and then they are moving forward to get an indictment. Here, as you noted, Lisa, the grand jury had voted to indict on these charges weeks before he was even arrested. So at this point, once he's actually retained counsel, been advised, there'll come the point where he will enter the plea. And then at that point, you're going to start the process of, in terms of the government handing over discovery, his attorney and him will start the process of actually going through it. And then we'll just have more developments in terms of what they decide to do. Do they decide to start plea bargaining? Do they look at the evidence and say, hey, maybe this is one where we should actually go to trial? At that point, we'll see. But for right now, we're so early on in the process that they just want to make sure that he's represented. And then from there, they can start the process of the prosecution.
And they always tell the media, because I will call them a spokesperson for the U.S. Attorney's Office for the public information on a case like this, and they'll go, the investigation is ongoing. Is it really ongoing, or is that just what they say because, hey, stay tuned, there could be more, there could be other things?
I would say the whole of the budget for the Department of Justice is to continue ongoing investigations. I mean, there are situations, Lisa, where even following a trial, following a guilty or a not guilty verdict, there's still an ongoing investigation with respect to the same set of circumstances that led to that trial. The U.S. Attorney's Office, the FBI, any of these federal agencies, as you can imagine, they investigate. That's what they do. So when you get that response from the Public Information Office, as cliche as it may be, I can tell you 100% as a defense attorney, they're being honest. There is an ongoing investigation. And, that may be another area where whether you're TSu Surf or you're any of those other defendants that are listed on that indictment, that's where you're going to be nervous because that investigation continues.
And there's no requirement, or is there a requirement that if you are the target of an investigation, you don't necessarily know it? A lot of times it seems that the defendants, they didn't realize, they thought, okay, maybe I put the streets, in some cases, maybe I put the streets behind me, and then now all of a sudden it's caught up with me, but there's just, they didn't know they were targets. So I guess the feds would not want to show their hand, right?
Exactly. And so, because when they show their hand, you have a number of things that can happen. Either a subject of an investigation decides to flee, right? And take themselves maybe out of the country, or, just be in a position where it becomes very hard to extradite them back to the United States. That's the number one thing that they're always worried about. And then number two is it could really put someone in a position where they either start trying to go back and retroactively clean up their act, right, or they cease further criminal activity that maybe the government was hoping that person would continue to do one or two more acts that could maybe get them to a higher level of charges that could keep them behind bars longer. But if there's now information that clearly people are being arrested, and I am actually a boss or some member of an organization that catches wind of that information, I'm going to shut everything down. Of course, the government doesn't want that happening. So that's a lot of times why they continue these investigations in silent. It's why you deal with a lot of these sealed indictments, because they just don't want to show their hand. And then you have people that are subject to these investigations making decisions based upon that.
All right. Well, Phil, thank you so much for breaking this all down for us. I'm sure we'll be coming back to you, as we always do, as the case proceeds. And thank you so much for being our legal commentator on
I just got a lot of information from watching that. So they said in September they executed the indictment, but it was sealed for a few weeks for the sake of not allowing anyone to know that anyone was coming for them. From what this guy is saying, if you were to exclude the charges, from his experience as a federal attorney, if you were to exclude just the charges alone that are being placed, the 3 or 4 charges, whatever they are, this attorney, that Lisa Evers interviewed, is saying 20 years. He said, that's a number that's probably bringing anxiety. And the fact that he mentioned, which is very important, that they've had a 5 to 7 year head start on this investigation. To think that somebody has a 5 to 7 year head start on you, 1 year is enough, but 5 to 7 year head start, and you have months or less to compose 5 to 7 years of your knowledge into one argument to fight for your life. It's crazy. It's insane. The feds are insane. They have a crazy rate of success, as we already know. But at the same time, as this attorney has um, been known for, they do lose cases. So anything is possible. So, and until otherwise, free surf, you know, it's an unfortunate situation. I wouldn't want anybody to be in it, but this is definitely something that he has to fight. So, and I believe, let me check this. Let me check this out real quick for y'all. I sent out these. I sent out. They had. Yeah, here it goes right here. Let me take this off. Put this up for y'all so y'all can see this. If anybody wants to contact them. Impact letters. You see this? Let me move this off the screen. This brand. Impact letters. This is what is needed right now. All right. We are in need of impact letters for TSu Surf. Please mail your letters to the address below by Tuesday, October 18th, 2022. This was something that, and I believe that even if still any any type of good letters or anything, I feel like you should still send him on his behalf, because like all the support, these are the type of things that people have to take into consideration. People who say, yo, he did this for me, he did that for me, or he changed this or he changed that for me. There's times where he, spoke in the community. I've watched videos of him in the community talking. So, salute yo yo. All of these things are good, all positive, impactful messages, letters. These things are all helpful. So, but yeah, give me a few. I'll be back. Tap back in with y'all. Love, life, and loyalty. The motto: stay safe, stay on, stay true. You rock me, I rock with you one.